Yes, please.
Item number 1 and 2.
Yes, ma'am.
You have placed the technical evaluation,
Right, Milord.
the proceedings.
Yes, Milord. So, because yesterday I've been able to show the minutes of meeting of the technical committee,
Yes.
and I was, my lords, inviting your lordship's attention yesterday. The last thing, my lords, was the minutes of meeting after the opening of the financial bids, where all financial bidders were called
Yes, yes. And to agree.
and to agree.
Yes.
So, post the discussion amongst the L1 bidders, the successful bidder was identified.
Yes.
And, my lords, then thereafter, my lords, just note page 121 of the appeal paper book, which is the work order which has been issued in this matter.
Yes.
And it specifically says that it has been issued to Mr. Tabin Varjiri, who has quoted the estimated value of the work as prescribed by the department.
Yes.
Now, my lords, this is as far as the evaluation process is concerned, from the technical aspect to the financial aspect. Work order finally being issued on 15th February 2024. Now, my lords, here
Work has commenced.
work has commenced.
How much? What percentage of it has been done?
My lords, I believe the successful bidder, my lords, is in a better position, but certain works, your lordship can also see, that is also indicated in the appeal paper book. Certain photographs are there of the works which have been commenced. So, and it is an admitted fact between the parties that the work has commenced.
Mr. Dotto does not admit it. He says that nothing has been done.
No, in fact, Mr. Datta's client has, in fact, preferred a contempt petition also, saying that works have been commenced, and it should not have been commenced because there is no writ appeal filed.
All right.
So that is a fact which is there, my lords. And contempt petition is still pending before the learned single judge. Oh, they have withdrawn. I stand corrected. That has been withdrawn on the last date.
That's all, Mr. Pandey?
My lords, just a few points and then I will end, my lords. I will conclude. My lords, here there is one aspect which is of crucial importance that has to be noted, is that there is one bidder by the name of Mr. Moonstar Kharkongor, who had also quoted an identical bid.
As Mr. Datta's client.
No, as the successful bidder and the alleged family members. But this person was an independent person. This was an independent bidder, and for that reason, my lords, I will just indicate the writ petition which has been filed at page 61 of
The other three were family members.
as per the petitioner, they are alleged to be family members.
Yes.
So, my lords, then a writ petition after the issuance of the work order has been filed, and I would invite your lordship's attention just to the memo of parties at page 71 of the appeal paper book. Page 71 is the description of parties, and your lordship can see at page 73, respondent number 9, 10 and 11 are the bidders. Tabin Varjiri, who is the successful bidder, Connie F. Swakme, and Colin Star Swakme. The name of Mr. Moonstar Kharkhongar is absent. So an independent bidder who also reached to the same price was not even made a party to the writ proceedings.
What is the full spelling, Moonstar?
Milos, it is also, I apologize, it is Mostofar. It is Mostophar, Mostofar Kharkhongar, and Kharkhongar is Karkongor.
K-O-M for monkey.
R for
Or rabbit.
yes, rabbit.
A-O-R.
K for
Yes, K-O-R.
Kongor.
Yes.
So it is Mostofar Kharkhongar.
A-U-R.
Well, it is Karkongor. And your lordship can find that name also in the additional affidavit at page 14. Additional affidavit of the state at page 14. The name is mentioned.
Page 14.
1-4.
Okay.
Right.
Yes.
So, my lords, the writ petition, I was at the writ petition, my lords. The writ petition, just to briefly indicate, paragraph 6 is the case of the petitioner before the writ court. Paragraph 6, page 76. It says that, my lords, that the petitioner respectfully states that pursuant to the aforesaid tender notice, the petitioner along with 4 other tenderers participated in the bid process. On 26 July 23, when the bids were opened, the prices of all tenderers were revealed, and it was found that Sri Tabin Barjiri, Connie F. Swakme, and Colin Star Swakme had quoted identical rates. Again, the name of that independent person is missing. Was found at the earnest money deposit had made by them stood at 2,87,900. The petitioner's earnest amount was 2,88,000, and one so and so has quoted so and so. The identical bid of 3 bidders. So Tabin Varjiri, Colin F. Swakme, and Colin Star Swakme. Not of Mr. Mostofar. Clearly indicated a cartel being formed amongst the 3 bidders. At page 77, the identical bid of 3 bidders clearly indicated that a cartel being formed amongst the 3 bidders, as there was not even a single paisa difference between the quoted prices. What ideally should have followed was that the respondent authorities ought to have immediately resorted to the technical bids. That is the case, technical bids, to evaluate the competence of the bidders before making any award of work on the basis of price bids. But the real scenario differed from what should have been the ideal approach, and instead all the bidders were shown to have qualified in the technical bid process. Your Lordship has seen that the technical evaluation has been done, and thereafter the financial stage had reached.
Yes.
Now, my lords, finally, based upon this, in the writ petition, there was no allegation of somebody being related to each other. That was, my lords, for the first time came before the writ court by way of an affidavit of service, which was filed by the writ petitioner. But be that as it may, my lords, on thereafter, this petition, my lords, was decided, and then I like your lordship's attention to the impugned judgment, which is at page 47. In light of these facts, my lords, directly, para 3 is the submission of the petitioner. Submissions of the petitioner are noted, my lords, and it specifically says that Mr. So-and-so learned counsel of the petitioner has submitted that selection of the respondent number 9 is vitiated by arbitrariness and malafide as firstly the identical quotation of rates by respondent 9, 10 and 11. Hints at cartel being formed by the respondents, and secondly the selection of respondent number 9 amongst the 3 bidders who had quoted identical rates clearly shows nepotism on the part of respondents, inasmuch as there is no justification as to how the bid was superior to the rest. It has also been submitted that the validity of 90 days has expired. And then, my lords, para 4 is the further submission of the petitioner, wherein it has been mentioned that it has further been submitted that the contract being an item rate contract, it was not possible to quote exactly the same rates as the quoted price given in the tender. He submits that the bid petitioner was only 1 rupee 34 paisa higher than the quoted rates, and if all the bidders are equal, at least they should have been invited for negotiations. So that is the case, that I should also be invited to negotiations, and I should have been awarded the tender based upon the certain technical qualifications. Now, my lords, just seize the determination of the learned single judge at paragraph 10 and 11. Paragraph 10 is at page number, my lords, 55.
It has already been placed before us. It is marked.
Yes, my lords. Para 11, I'll just re-emphasize para 11 because, my lords, that has some relevance, because your lordships thereafter passed an order asking us to file an affidavit. I'll place para 11. Para 11, your lordship will find at bottom of page 56. In the instant case, it appears that the tender committee had taken upon itself settling the contract when in fact the same is within the discretion of the owner of the contract or the authority that had floated the NIT. Reverting back to the meeting of 7 February 2024, it is observed that there is no mention about the technical aspect of the bids being examined, even though the NIT had fairly invited bids in a 2-bid system. No discussion in the present materials produced to attest to the fact that the conditions given in clause 3 to the detailed tender notice dealing with the technical aspects were noted or discussed. Further, the circumstances and manner as to how the invitations were extended to the bidders by the tender committee, the authority under which the meeting was convened, and the contract settled summarily in the meeting itself defies logic and reasoning. So, one of the considerations, prime considerations in passing the impugned judgment was there was no technical evaluation at all done. That, my lords, is basically countered by the additional affidavit that the appellants have filed in this matter. So, my lords, to the observations of the learned single judge in paragraph 11 are incorrect in light of the affidavit filed. Now, my lords, just finally, now, as far as the fairness in the process is concerned, it has been fairly examined, and the technical committee has evaluated the technical aspect, the financial aspect has been taken into consideration, and the lowest bidder, the corporation, basically in a contract like this, where certain construction work has to be undertaken, is mindful of the fact that the bid has to be accepted of a person who is giving us the lowest rates. And that has happened in this matter. So in that sense, below, the process adopted by the corporation in selecting the bidder is proper and does not suffer from any kind of arbitrariness. In this, as far as the question that has been raised in respect of cartelization, there are certain points to be noted in this case. Firstly, the identical bids have been reached by a person who is an independent person, apart from the so-called people who have been alleged to be related to each other. Secondly, the employer itself asks the bidder to first mutually discuss among themselves, and then if there is no understanding between the bidders, then the corporation would be undertaking the task of selecting the best person out of the L1 bidders. They could not have anticipated such a situation beforehand. And after that, an understanding has been reached amongst the L1 bidders that they don't want to pursue, and
The one who has been awarded is not part of the family.
He is alleged to be part of the family.
One who's awarded.
One who's awarded.
Only this Khargonkar was not. This
Yes, he was not.
Mustafa.
Yes. Yes, Manoj.
All four belong to the same family. Mustafa was not. Mustafa not made a party.
All three. There were 4 identical bidders. 3 belonged to a family. 1 did not. 1 did not. There are no allegations against that one person.
So he also went out.
He also went out. So if the process was of a collusion amongst the members, how did an independent person withdraw his bid? How did an
So
independent
that
person...
is not Mustafa, somebody else who went out. Or is it Mustafa?
Mustafa went out, Colin Star went out, and the other one more bidder went out. So 2 members of the family went out, and 1 independent person went out. So, Manoj, in this regard, I did some research, and there's one judgment which is exactly on point on cartelization in the tendering process. That is the judgment of Union of India versus Hindustan Development Corporation, 1993, 3 SCC 499. So, Manoj, in this...
2 plus 1 who went out, 2 family members and 1 independent person.
Yes, Manoj.
That did not include Mustafa.
That included Mustafa.
Included Mustafa.
That included
So
Mustafa.
that independent person is Mustafa.
Yes, yes, yes.
Yes.
I am relying, my lords, in this case on paragraph 17. So just to give a brief background of this case, what happened, your lordship can gather it also from paragraph number 3. Paragraph 3 are the facts. Here, my lords, if I may explain as to what happened in this case. Here, my lords, is a limited offer by the railway board for the purposes of cast steel bogies, and limited offer has been made to only a certain number of suppliers.
Yes.
In these suppliers, my lords, there are 3 big suppliers, called to be the 3 big suppliers, who, my lords, made an identical bid for the amount of the bogie on which they will supply the bogie.
Yes.
Apart from them, the other bidders had quoted certain other rates, but they quoted a rate which was identical. Thereafter, my lords, certain modifications happened in the customs regime, and they submit a subsequent offer which was also identical. Then the question arose that whether there was a cartel in this case or not. Identical bids, whether there is a cartel or not. And in that regard, your lordship can see para 17, which will give a picture as to what has happened in this case. Para 17. Para 17 was. Therefore, whether in a given case there was formation of a cartel by some of the manufacturers which amounts to an unfair trade practice depends upon the available evidence and the surrounding circumstances. In the instant case, initially, the tender committee formed the opinion that the 3 big manufacturers formed a cartel on the ground that the price initially quoted by them was identical and was only a cartel price. This, in our view, was only a suspicion, which of course got strengthened by post-tender attitude of the said manufacturers who quoted a much lesser price. As noticed above, it cannot positively be concluded on the basis of these 2 circumstances alone. In the past, these 3 big manufacturers also offered their own quotations, and they were allotted quantities on the basis of existing practice. However, a mere quotation of identical price and an offer of further reduction by themselves would not entitle them automatically to corner the entire market by way of monopoly, since the final allotment of quantities vested in the authorities, who in their discretion can distribute the same to all the manufacturers, including these 3 big manufacturers, on certain basis. No doubt there was an apprehension that if such predatory price has to be accepted, the smaller manufacturers will not be in a position to compete and may result in elimination of free competition. But there again the authorities reserved a right to reject such lower price. Under these circumstances, though the attitude of these 3 big manufacturers give rise to a suspicion that they formed a cartel, but there is not enough material to conclude that in fact there was such formation of a cartel. However, such an opinion entertained by the concerned authorities, including the minister, was not malicious or not actuated by extraneous consideration. They entertained a reasonable suspicion based on the record and other surrounding circumstances and acted in a bona fide manner. So, my lords, the sum and substance of the judgment is that merely because somebody is quoted the identical price, that itself is not a conclusive fact that there is a cartel. There may be a suspicion. That suspicion is not good enough for a cartel. in the facts of this case, and the Honorable Supreme Court also emphasizes on the fact that at the end of the day, the employer has the choice of picking or even rejecting a lower price. That is also the discretion with the employer. The same is applicable in the present case as well, because the tender conditions allowed even the appellant in this case to reject the price which with lower price or the higher price quoted by the bidders. So, my lords, in my humble submission, this judgment, my lords, is squarely applicable in this case, and merely on the basis of certain allegations and suspicions, my lords, it would not be proper to upset, my lords, the awarding of the tender in this case. Lastly, my lords, I indicate certain 4 or 5 points which completely nullifies, which may be taken into consideration while appreciating the questions of cartelization. First is, in the case that I have cited, there is no reserve price. Still, these bidders quoted an identical price without there being any reserve price prescribed by the department. And even in such situation, the Honorable Supreme Court says that is not a cut. Secondly, nobody could have predicted that the independent person would withdraw his bid. There will be certain independent people who will make the estimated price, would bid for the estimated price, and they will ultimately withdraw their bid.
Yes.
And in this case, my lords, that aspect has not been considered by the impugned judgment by the learned single judge.
All right, Mr. Pandey.
Yes, my lords.
Thank you. We can close the hearing?
Yes, my lords, from my end, my lords, I have to submit. I don't have to submit anything further, my lords.
Okay, bro. Please unmute it. Unmute.
My lord, there is another.
Yes.
Lordship, can you hear me?
Yes.
Next item is my item. I have been awarded with the contract.
Yes. Do you wish to add to anything? Do you wish
Yes,
to add?
Lordship. Yes, Lordship. There's much to add, Lordship. I'll need little time.
Wednesday. Wednesday.
Lordship.
Coming Wednesday.
Lordship. In VC, Lordship.
Yes.
Through VC.
Yes. Mr. Dotto?
Lord,
My lord, that is on 14th.
Yes.
The lordship is. Oh, yes. Obliged, my lord.
All right. Mr.
Lordship, I'm coming through VC, Lordship.
Yes, yes.
Lordship.
Once
Obliged, Lordship.
yes, once in VC, always through VC.
Obliged, Lordship.
Obliged.
Yes. Mr. Pandey concludes his argument. List this appeal for further arguments on Wednesday.
Lordship.
Item number 3 and 4.
Right. That's fixed.
Before my learned friend starts, my lord, I have a request. Mr. Paul, please. Your lordship had put item, at my instance, my lord had mentioned item 8 is in the list. Your lordship would call that at some stage. I do not know, because this will take till the item 8. I had mentioned it's come in the list, my lord. Basically, I have 2 minutes, something to say in that. In case your lordship does not call it, that's what I was indicating.
It's public interest litigation.
My lord?
Public interest litigation.
Yes, yes. I'd mentioned that so that it should come in the list. So your lordship would call it today. Otherwise, I just have something. Because this.
In case it does not reach, what is your submission, Mr.
Yes, in case it does not reach, I'm for the private respondent.
Yes.
It's relating to alleged illegal mining and all that. There is a report awaited from the state government, which has not yet come. Your lordship had directed the state government to file a report. I'm told it is not yet coming today also. Yeah, I was suggesting to expedite the matter, if your lordship gives directions for affidavit, as and when the report comes, we can file a short response to that, because otherwise the matter will get held up until the report comes, which may
All
take.
right, please wait, we'll call the matter. Huh?
I'm obliged.
You pass over this matter. Item 3 and 4.
Item number 5.
No, it's calling it.
Which is item number 5? PIL. Who's in item number 5?
My lord, I am for the respondent number in this matter.
What does it relate to?
My lord, this relates to the hawkers, my lord. To the hawkers. Fine.
I don't think you're going to call. You're going
We will take it up on Thursday, 15th May.
Thursday, my lord, very well. My lord, in the meantime, my lord, may I be allowed to file a short affidavit, my lord, against the PIL? But just a suggestions, my lord, not adversely, my lord.
But you're for the petition, huh?
No, my lord, I am for the respondent number 9, my lord.
In which case? Who is respondent number 9?
Respondent number 9 is
Don't
the
really
Meghalaya Greater Shillong Progressive Hawkers Association, Street Vendors Association, my lord. We have been arrayed as a respondent number 9, my lord, in the PIL.
That is the next matter. That is the
My
next
lord, in number 5, my friend is not the party. In item number 5, PL number 17.
I'm sorry, my lord, I'm in item 6, my lord. It's a connected matter, therefore.
So in my item, state has filed the report this morning as person's lordship order. So lordship may give us some time to go through the reports.
Lordship, item 5, this is the 5 and 6 traffic matter, Your Lordship. Pursuant to the last order, Your Lordship, today morning we filed an action taken report. Yesterday. Filed it yesterday. You don't know.
Now, what is your, you're for the petitioner?
I'm for the petitioner. I have received the report this morning. So lordship give me a week's time to go through.
Yes, Mr. Khan.
Lordship,
You have filed the report.
we have filed the report.
The state has filed, Your Lordship, for both the traffic and the vendors.
You want to, you're already added as a party.
My lord, I am arrayed as in the PIL number 9, my lord. That's item number 6.
That
No, this
matter-
one?
Not in this item.
Yes, it's my lord, both the common matters item. are connected. It's a joint report. These are tagged together, my lord, both the matters.
So we'll add your party here also.
Not in the item 5, my lord. Not
It's
in
in
the item
item
5.
6.
In the 6.
Not, it's in the same matter.
He's in PIL 10, Your Lordship.
See, item number 9.
We are in PIL 9. He's in PIL 10. Item number 6.
No, he's in this one. PL 9. In PL 9 2024, my lord, I am the petitioner.
My lord, item 5, two matters are tagged together, my lord. So my friend is mistaken. It is not item 6, my lord, it will be item 5.
So the issues are
The
common.
same, Your Lordship, and we have filed a joint report, Your Lordship,
All
both
right.
for PIL 17 and PIL 9.
After enlargement of the scope of this public interest litigation, comma, it now involves marked portion of order dated 7/3/2025. This part. Next, by our order dated 7 March 2025.
What director to file this?
Action taken.
Action taken.
Is this the order?
No. This is a report that relevant.
We had directed that the respondents should, on war footing, implement the policies, plans, and proposals contained in the report filed in court on that day. Full stop. These plans included demarcation of parking and no parking zones, acquisition of 35
Buses.
state-of-the-art buses to reduce private transport on the city roads, and shared mobility initiative bracket all capital STEMS bracket close project to enable school children to avail of buses to go to school so as to reduce vehicular traffic, regulation of identification and regulation of parking zones, street vending areas,
Correct. Very true.
and to prevent road rule violation by drivers. Common punishment for offenders and so on. By our said order, we had directed that by 6 May 2025, the Commissioner and Secretary to the Government of Meghalaya Urban Affairs Department would file another report showing further action which had been taken. Next, today, learned advocate appearing for the respondents has filed an action taken report. prepared by the Commissioner and Secretary. Prepared by the said Commissioner and Secretary. Full stop. It is quite detailed. With several documents and photographs as annexures. The said report is taken on record. Learned counsel for the petitioner. Wants to peruse the report. And file an affidavit in response to it, if so advised. Such leave is granted, the petitioner may file his affidavit in opposition by 15th May.
May, too early. Too early.
On the prayer of, we had, what is your client's name?
My client is the Hawkers Association, my lord.
That is in the next matter, my lord. That is PL number 9.
Let them be added here also. What is the problem?
Yes, yes.
We add
Meghalaya and Greater Shillong Progressive Hawkers and Street Vendors Association.
as a party respondent in both the writ petitions. List both the writ petitions on (21st May). All right.
Number 6.
Can you carry it?
Yes.
My lord, here I have prepared the report, my lord. I will be filing it today, my lord. So I have served the copy.
Is there any progress?
Yes, my lord. If my lord, just read the copy. Lordship, as per the earlier direction, Lordship, we are also filing a status report.
For the state?
For the state, Lordship.
The district magistrate has participated in the...
Lordship, yes. Amicus was directed to tie up with the district magistrates and he has submitted a report. So certain direction was given to us also, Lordship. We also have progress further. My lord, the first half of the report, my lord, it indicates the manner of cremation that is done by the Niyam Khasi, which is different from the manner that is conducted by the Hindu communities, my lord. If my lord will see the photograph.
Their coffin is placed atop the pyre.
Yes, and my lord, it is covered. If my lord will see the page number 3, my lord, photograph is there. The 4 walls from all the sides, my lord, it is covered.
No, to settle amongst them so that they share a crematorium, is there any progress made?
My lord, as far as the sharing of the same crematorium is concerned, my lord, what the Sankhasi, my lord, they have suggested the same place, my lord, that can be used for both the communities. However, my lord, there can be two separate cremation pyre, because even for Hindus, my lord, the manner in which the Sankhasi they cremate the body, my lord, that is not compatible as far as Hindu communities are concerned, because both ways are totally different, my lord.
Separate portions of the ground.
Yes, and in the same ground, my lord, there can be two different pyres. So for that,
Pyre or separate parts of the ground, demarcated portions.
Not necessary, my lord. It may without any demarcation, but there may be two different pyre, my lord, so that it can be.
Pyre is raised once the body comes.
Right.
It is not. It is not part of the crematorium.
Yes, my lord.
It is not something that is there. Wood has to be bought and a pyre has to be created.
Yes, that is for the Hindu, my lord.
They are also same.
As far as Niyam-Khasi is concerned, my lord, that is process is slightly different, because the they call it kpap, my lord, that is already there in existence, my lord. In the same place, they place the wood, my lord. If my lord will see the page number 3 photograph which has been enclosed, my lord. So what they have agreed to, my lord, is in the same place.
They don't put wood.
They put, my lord. They put
Then-
inside, my lord, from
Then-
below. From below, my lord.
So the places should be demarcated. Wood has to be bought.
Yes, yes. Wood is required, my lord. And as far as, my lord, Niyam-Khasi is concerned for the state of Meghalaya, my lord will see the page number 8. There is a great shortage of, my lord, crematorium as far as Niyam-Khasi is concerned. Page number 8 to 10, my lord. And in some places, my lord, where the land is available, that has been mentioned in the last column. And in places where, my lord, land is required, that is also mentioned here. There is altogether, my lord, 64 crematorium, my lord, that is urgently required. And in many places, my lord, they do not have the land.
This relates to the whole of Meghalaya or only Shillong district?
My lord, it involves, there are altogether 5 districts, my lord, where the requirement is presently there, my lord.
So you have made district magistrates of all the 5 districts?
My lord, I have met representative of these places, my lord, and it is from them, my lord, I have come to the conclusion that there is a requirement in all these areas, my lord. And even in Riboy district, my lord, Barnihat area, my lord, there are large number of Hindu populations, my lord. There is no crematorium, my lord, in that place. And they, if in case of death, my lord, they have to take it to the
Khan,
Assam.
we have received information, and of which we take judicial notice, that there is a similar problem in the Christian community. The various denominations and number of cemeteries is limited, and one denomination does not want to share a cemetery with the others, right? That is the in many places. So if the scope of this writ could be enlarged to include that also.
As your lordship pleases, yes, yes.
You make a preliminary inquiry and file a report.
My lord.
As of now, the scope of this public interest litigation was confined to facilitating the cremation of persons belonging to the Khasi and Jaintia communities, as well as those embracing the Hindu religion, comma, throughout the state of Meghalaya. The problem was with regard to death of crematoria and unwillingness of members of these communities to share a crematorium with each other. By our order dated 8th April 2025, we had noted the proposal of the government to construct new crematoria in various areas of in various regions of the state. That would entail time. Full stop. In the meantime, we had directed the amicus curiae appointed by us to hold meetings with the district magistrates and representatives of the said communities for sharing of crematoria. Today, Mr. N. Sincon, amicus curiae, has filed a report. He submits that after holding meetings with the aforesaid persons, a way has been found out for members of the Khasi and Jaintia community to share a crematorium amicably with their Hindu brethren by allocation of separate portions of the crematorium for each of these communities, and by provision of different and by rights given to each community to erect a separate fire in a separate portion of the crematorium for cremating their dead. Paragraph. This court also takes judicial notice of the information it has received that various denominations of the Christian faith are also facing similar difficulties in burying their dead in cemeteries. Full stop. A cemetery controlled by one denomination is not allowing dead bodies of persons belonging to another denomination to be interred or buried not or buried, interred in the same cemetery. Full stop. The result is that in various areas of the state, various regions of the state, long distance has to be covered by members of a bereaved family to perform the last rites of the dead. Full stop. There is also similar need for sharing of cemetery and for allocation of new areas as cemeteries for the Christian community. Paragraph. We enlarge the scope of this writ to involve to include the Christian community also. The amicus curiae is to hold a similar meeting with the concerned district magistrates with regard to the problem faced by the Christian community, attempt at resolution of the same, and file a report. The state is also directed to file a report to indicate whether it has any plan of increasing the number of cemeteries for members of the Christian community. Such reports are to be filed by June, by 7 June. List is public interest litigation on 10 June.
Lordship, just have
10th or 12 June. A report by 9 June.
it was a small prayer to make.
Yes.
Lordship, if all the three district councils, KHDC, GHDC, and the GHDC are made party, because state has to, has to coordinate for administrative purposes, Lordship. And
those under the scope of this writ, those 3 district councils, Khasi, Jaintia and Garo,
Lordship.
are hereby made party respondents. The Registrar General of this court will transmit copies of the writ petition on the chairman of these councils,
Oblige,
on
Lordship.
the chairman of each of these councils.
Number 7.
Please,
Mr. Paul, we will take this up next week for lack of time. Your matter is there waiting.
Lordship.
List is public interest litigation on 15th.
Yeah, I am in this matter.
Yes, Mr. Vaidya.
I'm also in 8.
You're in 8?
Yes.
Well, this covered by instance because it was on a holiday, so this matter is a public interest litigation, number 8. Your Lordship had given a direction to the state to file a report. Your Lordship had passed an order. So, state is here, I believe.
My lord, I am appearing for the state, my lord, in this case. My lord has given direction to conduct an inquiry, my lord. The inquiry is ongoing, my lord, so we require some time.
In fact, my lord, I am appearing for petitioner, your lordship. As per the direction of this honorable court, my lord, state was directed to, my lord, conduct an inquiry on the petition filed by the petitioner as a complaint. But what they have done, my lord, in the notification, they diluted the scope of the inquiry, my lord. In the petition, the allegation is, my lord, without having license for mining, my lord, limestone, respondent number 9 indulge in the activities of mining limestone and preparing, my lord, cement, and, my lord, availing 100% tax exemption and subsidies amounting to rupees, my lord, more than 200 crore, your lordship. But, my lord, your lordship, if your lordship will see the notification, it says only that on the basis of illegally inflated capacity. This is not only the allegation. In addition to that, my lord, this is the
Well, I would humbly submit your Lordship will hear us on this before expanding the scope. There may not be any prima facie case to do.
But, my lord, in the order,
your Lordship hear us on. Hear this.
They will file a report in terms of this order.
That's all.
We are not concerned with any
make a submission.
interpretation they have made of the order.
That's
We will see whether they have complied with the order or not.
That's
my
all.
lord, if that is there, my lord, I have nothing to say now.
You're the banking institution. Nothing much to say. Banking.
This public interest litigation was admitted on 19th February 2025 on the complaint made by the writ petitioner that the respondent number 9, Amrit Cement Industries Limited,
Tell the judge.
that it was mining limestone in the Jaintia Hills region without a mining license. By an order passed on that day, we directed the state to treat the petition as an informal complaint, make an inquiry and file a report in this court before the returnable date. While making the inquiry, the necessary parties were directed to be noticed. Full stop. On the prayer of learned advocate for the state, time to make and conclude the inquiry is, when should we fix the matter, by which it should be complete?
My lord, I was suggesting this. Here's 4 weeks or whatever.
4 weeks, my lord, if I am allowed, my lord, I can conclude it.
So he will give it in 4 weeks, my lord. Thereafter, we will file, because we will file a composite counter to his report as well as the.
No, let the report come before the court.
Very well.
Thereafter, we will see.
So on 4 weeks later, the date will come, my lord. I may not be here on that date, but your lordship will give direction by affidavit for counter and all that. If your lordship feels I can.
No, when would you be available?
I am only, my lord, month of June, as your lordship knows, is our annual holidays. So I'll be back on working on 9th July, my lord.
We'll keep it after that, because I don't think the report will come before that.
Very
They will take time.
We can, I was suggesting something to cut it short. We can file the counter to the petition as it is, my lord. There's no difficulty to my learned friend's petition. Then later on, we can file some additional affidavit. That will save some time. We would like to do it before your lordship, if possible. Why not?
No, but then the report will become useless then.
Very well, then your lordship keeps it on
First, let the report come, and we will add that before preparing the report, they will give you a hearing also.
Very well.
Right.
Then your lordship kindly keeps it on the 10th of July, my lord.
All right. List is public interest litigation on 10 July. The report is to be filed by 2nd July with copies circulated to all the interested parties. Full stop. We add to our earlier order dated
19th
February 2025 by saying that in the course of inquiry, all the necessary parties shall be given a hearing by the inquiry officer.
Your lordship's pleasure is that the counter should be filed only after the report comes.
Let the report come.
Very well, very well. I appreciate it.
All right.
That will be a kind of inquiry report which you will counter in an affidavit.
My lord, one another pair, my lord. I have come from Guwahati, my lord. Item number 18, I don't think it will be taken up today. Can it be taken up on that day itself, my lord? When this matter is fixed, my lord.
July?
July, my lord.
Same matter?
No, my lord. It is different matter. Since I will come for this matter, so it will be, my lord, convenient.
Who's on the other side?
Other side, my lord, my learned. I already. My lord, please, my learned.
You are agreeable to adjournment till July?
But in fact, this matter, I'm agreeable if it can be remanded back to the single judge also.
No, that's a different matter.
Yes.
Or before that also, my lord. And before that also, my lord.
Item number?
18, my lord, 18. After 6th of June, my lord, any day.
You have a junior here?
I have.
Junior here?
My lord.
When the matter is called, ask him to make the prayer. Why make it from today?
My lord.
It will be transferred to the list on Friday or Monday or this and that. When it is called,
May I pray, my lord, if your lordship may give one, if link may be given, my lord, it will.
No, we are asking whether you have a junior here.
Junior is here, but
yes.
Sometime it may, if link is there, my lord, somebody will appear and apprise your lord.
All right. Yes.
That operator.
Yes, call that spirit matter.
Deeply obliged. That observation, my lord, otherwise they are not giving link.
Second call, item number
Ask
3
him
and
to
4.
give the link in it.
Item number 8. Deeply.
This matter is fixed tomorrow also. Tomorrow also. Today is the third day.
Please, my lord.
Yes.
Well, sir. Very quickly, Millets, I'll try and recapitulate whatever I submitted before your lordships, Millets. The petitioners before your lordships are the bonders.
You did not, Mr. Paul, we remember it vividly.
Only thing that I was trying to submit yesterday, Millets, just taking it forward from where we were yesterday, I had pointed out, Millets, that during the currency of this writ petition before this lordship, before this honorable court, Millets, what has now happened is the technical committee, Millets, gave a finding saying that there may not be a level playing field. And I've taken your lordships to that report of the...
And the second central...
And therefore they suggested, my lords, that a second CBW be brought in.
And a writ has also been filed challenging that.
Challenging that, my lord, which your lordships have now...
And that writ has been added to this list. That it will be taken up after this.
This list.
Yes.
Now, why, well, that becomes relevant for our purposes in this writ petition is, well, it establishes the fact, and in my humble submission, that would go on to the extent of being an admission on the part of the state that the policy of creating a CBW, my lords, was actually creating a monopoly.
Yes.
Well, to this extent, what I had submitted before lordships was there were two reasons that had been given by the state so far as that the CBW, the first CBW is to be concerned. One was augmentation of resources and checkage of leakage of revenue. In leakage of revenue, my lords, I had already pointed out before lordships that the earlier regime was already in place where, my lords, we were required to prepay the ad valorem.
Yes.
In that context, my lords, I had submitted before your lordships that your lordships would then examine the proportionality of bringing in this legislation in the first place, replacing it with a regime, my lords, where there were 45 players, there was a level playing field, and then, my lords, bringing in another layer on top of it and requiring all those 45 to buy from that one entity. Coupled with the fact, my lords, that there is an admission on the part of the respondent number 6 that they have interest both upstream and downstream.
Yes.
To this extent, well, I'll just place a couple of judgments, well, on this issue. These are all settled laws, but well, on the doctrine of proportionality, the first judgment is 1991, 1 SCC, page 212. 212. Have a copy? Yes, sir. Court master.
Thank you. The government panel one.
Paragraph 29, my lords. My lords would find it at page 239. May I read, my lords? If my lords have it, may I read it? It can no longer be doubted at this point of time that Article 14 of the Constitution of India applies also to matters of governmental policy. And if the policy or any action of the government, even in contractual matters, fails to satisfy the test of reasonableness, it would be unconstitutional. We can skip this part.
This is an exception to the rule that the court will not interfere in policy matters. Yes, if it is arbitrary, violative of 14.
Two tests, well, it's reasonable. We will be dealing with one entity. It's absolutely absurd. Coupled with the fact, my lords, that at this stage it is coming from the state itself. That, my lords, that the reason why this policy was brought in has probably not been met. It has rather created a monopoly. And therefore, to dilute the situation of monopoly that's been created, they want to create a second CBW.
Added to this is another point raised by Mr. Shah that the state cannot create a monopoly in private
business. It can create a monopoly in itself, my lords, but not an agency under it.
Not in a private business.
My lords. My lords. Well, it's the next judgment again on the same issue. Well, it's AIR 1960 Supreme Court, page 1080.
Para 40? Excuse me. It's an extra copy given.
You ask them to come in 5 minutes. Yes.
The distinction, my lords, between what had fallen from your lordships, my lords, that whether when the state can distinguish between the same set of people, my lords, operating on the same sphere. Paragraph 43, my lords, if my lords kindly have a look. It's not paginated. It's not paginated. There's no internal page. I'm sorry, Milits, there's no internal page from SCR.
Yes, para 43.
Para 43.
We have cited the relevant passages.
Milits, we have cited the relevant passages from the textbook and decisions not with a view to define the scope of reasonable restrictions in Article 19(5) of the Constitution, but only to point out that as between citizens, the individual proprietary rights are ordinarily respected unless a clear case is made out for imposing restrictions thereon. There must therefore be harmonious balancing between the fundamental rights declared by Article 19(1) and the social control permitted by Article 19(5), in our case would be 19(6), my lords. It is implicit in the nature of the restrictions that no inflexible standard can be laid down. Each case must be decided on its own facts. But the restrictions sought to be imposed shall not be arbitrary, but must have reasonable relation to the object sought to be achieved and shall be in the interests of the general public. The reason why this legislation was in the first place brought in, my lords, by the subsequent flow of events, is now sought to be undone by the state itself.
Yes.
Marriage. I'll not burden your lordship to the rest of the judgment, Millets. A more recent judgment of the Supreme Court, Millets, this is 1998 8 SCC 227, Millets. This is MRF Limited versus Kerala government. This sums up the law insofar as this issue is concerned. Para 13. My lords have it, my lords. I'll be placing reliance on paragraph 13 at page 233. Page 233, my lords. My lords have it.
Yes.
If my lords have it, my lords, may I just place paragraph 13. On a conspectus of the various decisions of this court, the following principles are clearly
Which paragraph?
1-3, my lords. At page 233, paragraph 1-3.
Yes.
My lords. On a conspectus of the various decisions of this court, the following principles are clearly discernible. While considering the reasonableness of the restrictions, the court has to keep in mind that directive principles of state policy may not be relevant for us. Restrictions must not be arbitrary or of an excessive nature so as to go beyond the requirement of the interest of the general public. In order to judge the reasonableness of the restrictions, no abstract or general pattern or a fixed principle can be laid down so as to be of universal application, and the same will vary from case to case, as also with regard to the changing conditions, values of human life, social philosophy of the Constitution, prevailing conditions, and the surrounding circumstances. A just balance has to be struck between restrictions imposed and the social control envisaged by Clause 6 of Article 19. Prevailing social values, as also social needs, which are intended to be satisfied by the restrictions, have to be borne in mind. There must be a direct and proximate nexus or a reasonable connection between the restrictions imposed and the object sought to be achieved. If there is a direct nexus between the restrictions and the object of the act, then a strong presumption in favor of the constitutionality of the act will naturally arise. Well, I am on the corollary of this. If the object of the act is itself defeated, inadmission, that we brought in a law, it has not served its purpose. On the contrary, it has created a monopolistic practice in favor of a certain person, my lords, or an entity. Then, my lords, the doctrine of proportionality will come in, and the reasonableness behind bringing in that law, my lords, itself gets defeated. Intelligible differential.
Yes.
Let's.
You continue tomorrow, Mr. Paul?
Well, I'll take 10 minutes, I'll tomorrow.
And thereafter, anybody else to make submissions?
From petitioners, my lords, we would reserve our rights for rejoinders. The state and the private respondent will have to begin.
The petitions are over.
My lords, Mr. Shah has already concluded in the first matter, my lords. I am in the second matter. I'll conclude tomorrow. I'll take 10 minutes, 10 to 15 minutes maximum.
Mr. Vanji, you will be able to begin tomorrow?
I can start tomorrow. Well, I've taken 8 days or 8 sessions.
List tomorrow as per schedule. To enable Mr. Paul Leonard, Senior Advocate, to continue with his submissions.
Ali Blaj.
Lordship, if I may just crave your Lordship's indulgence for a moment, Lordship. In
Yes.
item number, I've come from Guwahati, Lordship. In item number 9, I just need to pray for time to file an affidavit. The state government has filed a report today with regard to the inspection regarding the overloading of trucks matter, Lordship.
Yes.
Your Lordship had directed an inspection to be carried out and a report to be submitted. So the report has been submitted just today morning. I pray for time to file my affidavit in response to
We have to see the report. We will keep it on 15th.
15th,
List
Lordship.
this writ application on 15th.
Lordship, if it could be on 16th, Lordship.
16. All right. 16th.
Keep your blessing.
No mentioning. Like this.